For an old-fashioned lecture, okay? I haven't done this in a while. Usually I have slides, but... So the topic is law and the poetic imagination. Wallace Stevens, in my view, and the view of those who know more than I about such matters, is one of the greatest American poets of the 20th century. I'm a great admirer of his work. I hope it's a fitting tribute to his legacy to speak this evening on the subject of law and the poetic imagination. I realize that this is a juxtaposition that at first blush might seem a little odd. If I am successful after this talk is over, you'll take your leave thinking, law and the poetic imagination, how could it be otherwise? But first, we need to deal with that initial sense of strangeness. In thinking about my topic, it occurred to me that I might easily have entitled the talk, emulating a treatise by Philip Sidney in 1595, In Defense of Law and the Poetic Imagination. But in defense against what? This train of thought helped me to crystallize my objective, for I realized that I would very much like to persuade you that there is an imbalance in contemporary thinking about law, and that imbalance is reflected in legal education. Law sits uneasily between the social sciences and the humanities. It assimilates insights and methods from both. From this somewhat precarious perch, leaning at times towards the interpretive arts, at times toward scientific explanation, jurisprudence maps out the basis for a sustainable social and political life. But law is no mere blueprint. It is a form of life. Law must perform the felt values that it embodies. In a word, it must constitute the nomos, the discrete universe of legal meaning in which we live. The poetic imagination is what brings sustainable worlds of meaning into existence. It is also what maintains or destroys or transforms them. As Vico wrote over 400 years ago, the poetic imagination is what entices the soul and impels it to love. For once it loves, it is easily taught to believe. Once it believes and loves, the fire of passion must be infused into it so as to break its inertia and force it to will. In more recent times, the impressive cloud of scientific rationality and utilitarian calculation have tended to overshadow the role and authority of stories and feelings. This imbalance stands in need of correction. So if this is a defense of law and the poetic imagination, or of law and the humanities, if you will, it's also a quest for recognition. We need to give the humanities their due. And I say this not for the sake of the humanities, beleaguered though they may be, but for law's sake, for the sake of law's humanity, perhaps. In homelier terms, my defense seeks recognition of the fact that it is feelings, not logic, that bind us to the law. Feelings constitute the bonding agent that holds society together, sustaining our commitment to the rule of law and to the everyday business of resolving conflicts, one case at a time. It is the business of the poetic imagination to crystallize and manage the way our emotions respond to others and the world around us in the process of drawing meaning from experience. And here's a related point. Speaking of imbalance, for a long time now, aesthetics has suffered a bum rap, as if it were a mere matter of style, of cheap tinsel without substance, a mere matter of taste. You can trace this devaluation all the way back to Plato. I'd like to contest that view. Instead, I'd like to persuade you that aesthetics involves a lot more than taste. It concerns the modulation and amplification of sensorial perception. Aesthetics deals with particular ways of being in the world, of our being in relation to things and others around us. Aesthetics involves how we engage the endlessly variable presentations and demands of others and events. It concerns how we attune ourselves to the world without necessarily reaching for a category or concept, or for that matter, a rule or principle, all of which wait in the wings, ready to organize reality. It's like Carl Llewellyn's situation sense, the jurist's ability to grow attuned to the facts of the case, including the backstory, like walking into a room and catching a vibe, a mood. In the realm of aesthetics, unbound by abstract concepts, we grow mindful of the role played by feelings in stories, images, and metaphors, the way feelings shape and amplify meaning. So the devaluation of aesthetics as a mere matter of subjective taste is part of the imbalance I'd very much like to redress. Let's start then with the matter of feelings. These days, if I were in search of authority to make a claim about feelings or the imagination, I'd probably be well advised to cite recent neuroscientific studies. To prove my point, I'd show you fMRIs, functional magnetic resonance images. Images of the brain lighting up while digesting poetry. The imagination must be here in this anatomical sector, or maybe spread around here and there, I might say, with arrows and colorful slides. But that's not the path I want to travel this evening. I want us to consider a poem, a wonderful poem by Wallace Stevens. And alongside our reading of this poem, I want us to consider states of feeling. Like film and music, poetry is an emotional intensifier. When it works best, we feel something with great clarity, as if wistfulness, anger, longing, or love was somehow surging forth for the very first time. In Wallace Stevens' work, poetry is often the subject of the poem. Through his poetry, we confront what poetry does, how the poet imagines the world, and how it feels to enter into that world. The poet's feelings bind us to particular images and the experience of meaning that they evoke. As I said before, feelings are bonding agents. They hold a narrative together, even as they make it come to life. Yet what happens to feelings in legal education? I vividly remember, as a first-year law student, how sometimes when a classmate began to speak, to answer one of those endless Socratic questions my teachers like to pose, the student might unwittingly begin with the phrase, "I feel that..." No sooner had those words hit the ether than a thunder of professorial dismay burst forth. Feel? You feel? Could you please try not to feel, Mr. Jones? I want you to think. In this class, you will learn to think. Now, as a law teacher, I perfectly understand that kind of response. The professor, like so many others then and now, was quite rightly seeking to cultivate intellectual discipline, rigor, logic, clarity. That's the order of the day. After all, rules must be extracted from a maze of verbiage, and students must be able to locate the rule's boundary. From what facts does it emerge to what other kinds of facts might it apply? What sorts of differences are likely to repel comparison and beg to be distinguished? These are hard moves to make, and they are the bread and butter of first-year law school. But as I reflect back on my student days and on my own career as a lawyer and law teacher, I've come to conclude that we do a disservice to our students and to the law we serve when we leave the impression that syllogistic logic and strictly rational forms of intellectual analysis are the only or even the best tools that lead to success in the practice of law. If Oliver Wendell Holmes was right when he said that experience, not logic, is the life of the law, and I think he was right, then it's incumbent upon us to follow through on the implications of that insight. There are important epistemological and cognitive implications. If experience must be mined for categorical knowledge as well as the effective knowledge of felt reality, different tools other than logic and calculation, must be included in the lawyer's toolbox. Inductive and deductive logic and the art of analogizing and distinguishing cases are coveted abilities in law school, but they only take you so far in practice. For always there remains the question, what compels the rule? Indeed, what compels the case? Why should the decision maker really care? To answer these questions, logic alone will not do. For ultimately, what compels attention and motivates judgment is the sense we make of the situation before us. And that is a matter not of logic, but of narrative. If we are to deal effectively with the messy business of making sense of human behavior, the kind of mess lawyers so often confront, we are going to have to extend ourselves and enter into the diverse and often unfamiliar experiences and feelings of others. I speak of our client's experience, of course, but also of the experience and feelings of the decision makers on whose judgments we depend. Narrative ascends to the particular, is how Jerome Bruner put it. By contrast, conceptual thinking is abstract and general. This distinction between general and particular, between abstract conceptualization on the one hand and particularistic narratives on the other, points to two completely different modes of thought. Each organizes the world in a different way. A good story and a well-formed argument are different sorts of creatures. They embody different ways of knowing and being. Arguments are modeled upon science and mathematics. They aspire to proof or verification. They seek empirical data that instantiate the rule or verify or falsify the hypothesis. Stories, on the other hand, aspire to the most compelling kind of verisimilitude, to lifelikeness, if you will. They are authorized by ordinary common sense, by our gut, our intuition, our trained and often unconscious susceptibility to certain ways of feeling and of constructing meaning. These different modes of cognition, argument and storytelling, may complement one another, but the one will never be reduced to the other. Stories cohere and move us when they comport with our sense of the world, or more rarely, when some brilliant artist, maybe like Wallace Stevens, imagines something new, perhaps something transformational, and compels us to live it as if it were our very own experience of reality. As Hannah Arendt has written, no philosophy, no analysis, no aphorism, be it ever so profound, can compare in intensity and richness of meaning with a properly narrated story. Of course, legal advocates in practice take advantage of both modes. For example, on occasion, lawyers might want to activate the logic of necessity. Prosecutors, say, in solving a murder mystery in court, want to prove who done it in order to compel the jury to reach a verdict of guilty. Criminal defense lawyers, on the other hand, carry a different burden. They must arouse doubt. But the best defense lawyers understand that raising doubt alone may not suffice. It is not consistent with human nature to enjoy being left in limbo. We crave certainty, narrative closure. What fulfills that craving when all that's left is reasonable doubt? Someone killed Mrs. Jones, but we don't know who. All I can tell you is it wasn't my client. Fine. But what will resolve the juror's nagging sense of disorder that the defense has now left behind? Maybe, at this point, another kind of story is called for. How about a hero quest story? Something like this. As jurors, you have sworn a mighty oath. Others will tempt you to discard it. They will tell you to convict and go on your way. But the oath you swore requires more. It requires courage and dedication to our highest values, an unyielding dedication to liberty and justice. If you can accept the responsibility that you have taken on, if you can have the courage to do your duty, you will acquit in the face of reasonable doubt. This is a classic example of the hero quest story. We encounter it often. It always makes the same moves. From the Hunger Games to George Lucas's classic film Star Wars, when Luke is called to the hero's journey but resists. Catastrophe strikes home, his parents are killed, and then he realizes he has no choice but to take up the quest he initially deferred. All stories are made up of recognizable elements. Lawyers need to know what story form to use when, how, and with what effect. In the case of the criminal defense lawyer, in order to go beyond residual uncertainty, we don't know who done it, the defense may turn to the hero's quest as a counter-narrative with its own brand of certainty and closure. This is the story of the juror hero who stays true to her oath no matter how sorely tempted she may be to abandon it. Stories like this compel action, including the act of judgment. And through it all, these stories comport with our common understanding of how the world works, how certain kinds of people and certain kinds of situations may be expected to behave. when the lawyer narrator evokes these familiar forms, predictable sorts of cultural associations, memories, and feelings come to mind. These images and feelings bond us to their source. This is what verisimilitude is all about. Lifelikeness, the lifeblood of the well-told tale. So what does it mean to include this tool, the capacity to construct the right narrative at the right time for the right purpose, in the lawyer's toolkit? This is the road that leads through the disorderly but not incoherent realm of human emotions. The poetic imagination is the main instrument by which feelings are illuminated, amplified, and arranged. This alerts us to one of the central tasks of the humanities, to make sense of our experience of the world and others around us. But how are we to know the meanings that matter most to a conflict's proper resolution? We know in part by the intensity of our commitment, which is to say, by the intensity of our beliefs, the intensity of our feelings. This is where the integration of ethics and aesthetics matters most. Law's humanity, the core meaning that we derive for self and others and the social world we inhabit, derives from and is sustained by the poetic imagination. How else are we to deal with difference? How else, when we lack direct experience, may we come to understand what it means to walk in the shoes of another, whether those shoes belong to a client or to the decision maker in whose hands the client's fate rests? Logic alone will not convey the situation sense of the client's case or its proper outcome. For that, you need a compelling story, a fitting image, an apt metaphor. These are the agencies of creative imagination, the agencies that compel belief and that inspire the feelings that bind us to the insights and judgments they bring to mind. Not because they so skillfully make things up. I'm not speaking here of the staginess, the theatricality or artifice of narrative, or of any form of communication for that matter. Rather, I have in mind those forms of expression that flow from our immersion in or attunement to the situation at hand. In making this distinction between artifice and authenticity, I want to push craft away from craftiness and toward lived experience. If you do not feel the power of lived experience when you compose your words or images, others are unlikely to feel it when they read or watch or listen. Without the vitality and the inexhaustible excess of lived experience pulsing through your words and images, craft has dramatically less to work with. What we are left with is craft working craft, a reflexive process that wearies us with its emptiness. That's when the sour taste of craftiness takes over. If you immerse yourself deeply in the facts, the story you tell will remain anchored. The deeper your attunement, the more likely the whole will resound beyond its parts. Insight, understanding, mindfulness, all these capacities are aesthetic in nature. They are capable of endowing knowledge with eloquence. This is the proper domain of meaningful experience. And this, too, is precisely where poetic imagination builds a home for us, nudging us away from solitude into the shared life of civil society. This is how Vico defended poetry and the creative imagination, in the service of shared images, shared stories, and ultimately shared values. This is also why for so many centuries law was considered the queen of the arts and sciences, because law constitutes and maintains the core narratives that make society cohere and live. It curtails the ferocity of fools, as Vico put it, turning them from error through prudence and bringing them benefit through virtue. That's what it's like for the ethical and the aesthetic to merge. It's the old rhetorical ideal, expressed in the oft-quoted adage, eloquence without knowledge is hollow and empty. But knowledge without eloquence is mute and powerless. It's with this aspiration in mind that education in general, and legal education in particular, most urgently needs the humanities. For it's not in logic or calculation, but rather in the interpretive arts of the humanities that we learn to cultivate creativity, memory, and perception. These are the most necessary capacities for music, film, poetry, and eloquence. They are the capacities most necessary to weave together the ethical and the aesthetic, harnessing eloquence in the service of virtue, what jurists call the quest for justice. Eloquence uprooted from wisdom. Eloquence let loose in an unruly material world driven by passion, greed, deceit, and the urge to dominate others. A world governed by markets, bound solely by individual calculations of maximized pleasure and minimized pain. Eloquence in the hands of advertising and propaganda, divorced from knowledge and the situation demands of the ethical, lies at the mercy of totalizing emotions, totalizing ambitions. These ambitions may be hyper-erotic or hyper-rational, driven by messianic fervor or by the cold, bureaucratic calculations of the totalized state. Beauty and justice are vital allies against such totalizing forces. Beauty enchants us by the expressive force of eloquence, while justice compels us by the unsurpassable, untotalizable force of its ethical demands. The sense of being obliged by or responsible for the world as it unfolds around us, responsible for the other who stands before us in her need. The poetic imagination takes us across the great Cartesian divide that separates mind and body, as well as mind and nature, or nature and sign. Through aesthetic modes of attunement, we learn the demotion of self in fealty to the actual. That's the path to the ethical, the endless call of incalculable justice. Through the poetic imagination, we learn to immerse ourselves in the facts of the case. And from this immersion, we learn to intuit the living speech of law. Now, what does it mean to speak of speech that lives? Wallace Stevens writes in his poem of modern poetry, that's the one in your program, it has to be living to learn the speech of the place. It has to face the men of the time and to meet the women of the time. It has to think about war, and it has to find what will suffice. Not cliches, not hackneyed terms from old familiar scripts, but rather something that arises from what is real, what is before us, what the attuned mind allows to unfold. As Stevens writes, the poem of the mind in the act of finding what will suffice. What will suffice? Words that suffice describe the emergence of meaning from lived experience. This is what provokes, as Stephen puts it, a sense of sudden rightness, a meaning that will suffice, a meaning that wholly contains the mind. That sense of rightness, again quoting Stevens, is something below which the mind cannot descend, beyond which it has no will to rise. Not a bad description of eloquence. The capacity to harmonize signifier and signified so that a greater excess resounds. This is an uncanny excess because the meaning it conveys remains irreducible to the form that creates it. Can jurists dare to seek, much less find, such satisfaction as this? The satisfaction of experiencing a sudden rightness, the satisfaction of encountering a meaning that wholly contains the mind, a satisfaction in the art of expression that creates the very stage on which it performs. These are the conditions of ethical persuasion. The moment when the other accepts a proffered meaning as his or her own, the construction of a shared world and of a self that feels at home in that world. This is the most important creative act that law and the poetic imagination perform. But can law poeticize? It can, it does, and it must. For that's the very source of law's humanity. We witness this most palpably at critical moments in history, when a set of values attains new vitality, in times of revolution, civil war, historic outbursts of social transformation and political liberation, manifest perhaps in new forms of constitutional reconstruction, when, as Bruce Ackerman has written, the various branches of government align, finding new meaning in a shared cluster of values. like the era of the New Deal, which gave form and purpose to a middle class that might emerge from the devastating loss and suffering of the Great Depression. The poetic imagination gives life to shared values on a macro level, when political and social upheavals are at hand, and also on a micro level, every day, one case at a time. These individual and collective acts of meaning reconstruct our humanity. They tell us what it means to be human now, in this place, in this time. This kind of meaning comes not from the barrel of a gun, but from an act of discourse, an act of persuasion, which presupposes, by definition, the freedom and the power to say yes or no, to accept a rule or a decision or a cluster of core values because they are right or just or fair, because they make sense, because I can live with myself and with others in such a world without despair. I accept. That's the keynote of legitimate as opposed to naked power. Law's humanity, then, is an act of collective imagination, poetic imagination. We encounter it on the great stage of history and also in smaller dramas that play out one case at a time. Cases like Wagner v. International Railway, for example, which my tort students are laughing, which was composed by one of the great masters of legal rhetoric, Benjamin Cardozo. The legal challenge in that case was plain. Can we say that a train company is responsible for the death of a passenger who chooses to leave the car he's in while it's perched high on a bridge at night? The passenger decides to descend onto the tracks in search of his cousin, who minutes earlier had been thrown out of an open door. That the train company is liable for carelessly creating the conditions that led to the cousin's death is beyond debate. But did they also cause plaintiff's death when he fell from the tracks on a deliberate mission of rescue? How we define proximate cause is the question. That's the simplest way of putting it. The artistry with which Cardozo answers this question is anything but simple. How are we to think about this rescue as action? Is it the train company's fault if he decided to bear the risks of rescue under such obviously dangerous conditions? Is this not an intervening, superseding cause that cuts off the train company's liability? Not according to Cardozo, whose judgment vividly embodies the power and authority of law when it's seamlessly united with the poetic imagination. Peril and rescue must be in substance one transaction, Cardozo writes. The sight of the one must have aroused the impulse to the other. It's my imitation of Cardozo's authority. Impulse, mind you, not deliberate reflection. Here's another quote. The emergency begets the man. Snappy. As if the brevity of the sentence emulates the quickness of the very impulse at issue. The human mind acts with a celerity which it is sometimes impossible to measure, says Cardozo. So we must look at the circumstances. For, as Cardozo puts it, the act is the child of the occasion. Note again the key theme of necessity, impulse, quickness, as opposed to deliberation, the pause that might break the chain of causation. Danger invites rescue. The very sentence, both in its swiftness and its substance, dictates the proper outcome. The railroad company created the conditions that impelled the act in question. So they own both cause and consequence. But Cardozo does more. He captures our belief by vividly evoking how the rescuer must have felt alone at night, up there in the dark, on those narrow, precipitous tracks. Cardozo humanizes the rescuer, first by naming his cousin, naming him in a most personal way, not formally by his surname, but by his given name, Herbert. It's in search of cousin Herbert that our rescuer sets out. That's what he writes. We are meant to enter into the plight of rescue under the very circumstances in which it occurred. And with that in mind, listen to how Cardozo describes the penultimate scene just before the plaintiff rescuer, like cousin Herbert before him, falls to his death onto the ground below. This is how Cardozo writes, "The car went on across the bridge and stopped near the foot of the incline. Night and darkness had come on. Plaintiff walked along the trestle, a distance of 445 feet, until he arrived at the bridge, where he thought to find his cousin's body. Several other persons, instead of ascending the trestle, went beneath it and discovered under the bridge the body they were seeking. As they stood there, the plaintiff's body struck the ground beside them. Reaching the bridge, he had found upon a beam his cousin's hat, but nothing else. About him there was darkness. He missed his footing and fell." Talk about the mind in the act of finding what will suffice. Just consider for a moment what's going on in this judicial text. For example, how one of the facts central to the legal issue, the fact that plaintiff deliberately chose to walk the length of a football field, 445 feet, to reach the site of his cousin's demise, is reduced here to a mere subordinate clause, a rather minor detail in a much larger drama. And what a drama it is. We can picture it. Night and darkness have come on. The rescuer searches, expecting to find his cousin, but what does he see? A hat upon a beam and nothing else. And nothing else, such a stock image, jolting the reader into vicariously experiencing the rescuer's own intensity of feeling, the shock of it, the terrifying aloneness at the moment of realizing what has happened. And did you catch the narrative construction that Cardozo uses here? He gives us the rescuer's fall twice. First, plaintiff's body falls among those who had gathered beneath the trestle. And then we encounter a veritable replay when plaintiff finds his cousin's hat upon a beam and nothing else, missing his footing and falling. What do you know? It's a flashback. Now, why in the world would Cardozo produce a flashback? Why present the death twice and in this particular fashion? What's going on here? Having already fallen among the crowd below, the reader must experience the replay of that fall as inevitable. There's a name for the dramatic technique in play here. It's the genre of suspense, like in a Hitchcock film. The audience already knows what's going to happen. The victim's death is imminent and inevitable. The movie viewer, but not the victim, sees the madman with the knife poised, ready to strike the unwitting victim as she enters the shower. "Don't go in!" we all want to shout. But of course she does. Our knowledge of the inevitable, suspended briefly in time, provides an opportunity to build and intensify our response to what we know must occur. This drawn-out moment of anticipation or temporal suspension is the essence of the suspense genre, as its very name reveals. Suspense is designed to amplify emotion. I believe that Cardozo flashes back to replay the plaintiff rescuer's death precisely in order to intensify our emotional response. The emotional intensity with which we greet that death commingles with its inevitability. And inevitability is, after all, the essence of Cardozo's judgment here. Danger invites rescue. The act is born of the occasion. It is an impulsive act. And so, in short, plaintiff's death was bound to happen as soon as the condition for its occasion, Herbert's fall, preceded it. Having carelessly created the occasion, the train company can hardly disown the fatal rescue that followed. A legal decision, written with such liveliness, with such poetic imagination, reconstitutes the world and compels our acceptance. These are words that suffice, words that attune us to the facts of the case, because the attention of the writer is so focused, so immersed, so thoroughly enfolded in this very drama that we are led to experience it for ourselves. It's as if we were all seated together in a darkened theater of the mind, just as in Stevens' poem. There we are, the audience listening, as Stevens writes, not to the play, but to itself, expressed in an emotion, as of two people, as of two emotions, becoming one. Cardozo and Stevens may be seen as engaged in a similar venture. The poem of the mind, like the narrative of the case, in the act of joining us together in words of sudden rightness, words that suffice, and in so doing, make law a living reality, a reality that defines us and that helps to constitute the world in which we live. And so let me conclude. Why does law poeticize? Because eloquence and feelings bind us most surely. Law's essential narratives constitute the collectivity in which we live. And they do this not by force of command, not by fear of repercussions alone, but rather by the power of belief, of acceptance that it's right and good and just for law to act as it does. This is why even so prominent a legal positivist as H.L.A. Hart ultimately wrote that just because positive law has the power to command our obedience, that doesn't mean we want to obey. Positive law can obligate us to do or refrain from doing certain things, as from the barrel of a gun. But that doesn't mean we feel obliged to do so. It's our acceptance of the right to rule that ultimately legitimates what the rule asks of us. This shift from command to acceptance correlates with the shift from the formal authority of positive law to the eloquence and persuasiveness of law in proximity to justice. It corresponds with the shift from the imperious logic of explanation to the creative felicity of the poetic imagination. That felicity is the offshoot of words that suffice, words that carry and induce a sense of sudden rightness. These are words that arise from the jurist's attunement to what the facts demand. Authoritative discourse, the discourse of foundational law, is, as Joseph Vining once wrote, the act of making values come alive. This is not the work of logic. It is the work of poetic imagination. We experience it in the resonance of an uncanny excess. This is what ultimately compels us in all great works of art, whether it's beauty in painting, harmony in music, or eloquence in speech. When the union of signifier and signified is more than the sum of its parts, we encounter meanings that will suffice. Law is founded and maintained and sometimes transformed by such meanings. These are meanings that bind us with great intensity, with feelings that simultaneously clarify and enact the values they embody. In the end, the only alternative to founding states based on Hobbesian fear is to recurrently inspire such collective belief and collective affirmation. Feelings that sustain such affirmation may be generated by the words of poets, whom the poet Shelley called the unacknowledged legislators of the world. They also may proceed from the poet, lawyer, statesman. Such individuals may be rare, but as Cardozo and Robert Cover and James Boyd White and many others besides have written, these are the individuals who help us hold our universe of meaning together, by which I mean the nomos, the legal community in which we live, among others, in civil peace under the rule of law. To say law poeticizes, then, is simply to say this is how law begins, and how it may, if we are lucky, continue to flourish when meaning suffices. So we end as we began, with law's stories, stories that bind us by intensities of feeling generated by the poetic imagination. If I've persuaded you to entertain this insight as worthy of belief, I hope you will also agree that we can ill afford to leave the poetic imagination out of legal education. We must care about its cultivation. We must nurture it in the service of virtue, as Rico wrote so many years ago. We must seek to understand it anew in every generation, in words on the page as well as images on the screen. By what intensities are we bound or forced apart? To what acts of meaning do we say yes or no? And in so saying, whom do we become? And what kind of community or society do we create? In a moral society, we learn not only how to think and feel, but also to ask what it means to think and feel in particular ways, under particular circumstances. So go out and poeticize, attune yourselves to the world and others, live deeply. In so doing, you will come closer to knowing the living reality of law, and perhaps you will also come closer to the source of law's trust, its bond both to the past and to the future, something neuroscience will never adequately convey. For in order to feel bound to something larger than ourselves, We need to experience the intensity of that bond. This is what the poetic imagination is for, to live beyond fear and violence in the realm of meaning, bound by words that suffice. The great American jurist Carl Llewellyn once urged his students to love the law. The poetic imagination tells us why. For if we look deeply enough, listen closely enough, in law's poetic quest for justice, we may discern the very movement of love itself. Thank you.